tonight we're bringing you updates on two significant matters. Chairman Wontumi has been released probably less than an hour ago. Our Charles Kumi was there during the previous bulletin, brought us some highlights, and we just spoke to his lawyer, Frema Edunyami, speaking to one of his lawyers, who officially explained what he was cautioned of. But we'll take you back a bit into why he was detained and the sequence of events. I'll be speaking to two, I'll call them legal political minds. So Hassan Tampuli is MP for Gusau, and he is also a lawyer. He's in the studio tonight. Hassan, welcome. Good evening.
Thank you very much, Bernard.
You've been working overtime in opposition. You've been working overtime. This weekend you were all over. Today you are here. Thank you so much for joining us.
Always a pleasure to be with you.
We are also privileged to be joined by the former MP for Tamale Central in the person of Inu Safuseni. He will join us shortly. He's joining us virtually to also express his views on these two very significant matters. Were you part of the MPs who marched to EOCO last week to demand Wontumi's release?
Thank you. Good evening, and good evening to your viewers. And in particular, good evening to the good and virtuous people of Gushegu, my constituents. So I wasn't in town that day. Okay. I was in the north for the funeral of the late Paramount Chief of Miang, the Miang Lana Abdullahi the Fourth. So that's where I was when that event took place. So I'm being told that it was done against the provisions of the Public Order Act and so on and so forth. As a matter of fact, I'm not too sure what that meant, because they could have driven to the offices of EOCO individually or even in a convoy. And then when they get to the place, they get off their cars. Would that be considered as a violation? So they chose to walk instead of driving in their cars. Okay. So there was no violation of the Public Order Act per se. But the reason for that move was that if you look at the antecedents of that whole incident, first on Friday 23rd, security agencies stormed the residence of Chairman Wontumi in Kumasi, and then insisted on gaining access. Of course, that didn't happen. And Chairman Wontumi's lawyer sent word that he will be visiting the CID, who were the ones who wanted him on that particular occasions. And then on 26th, Chairman Wontumi honored their invitation at the CID headquarters, went and then was given a police inquiry bill and requested to return the next day, 27th. He did same, right? He went to the CID, honored their invitation, cooperated with them, went under interrogation, and again was discharged to leave, granted police inquiry bill. It was just when he was stepping out that he was arrested in that Rambo style, which has come to be the best description of what really took place that day.
On Sunday, who did not agree to that description. I remember the host pressing him because he was with Wontumi in a car, and he said an official of EOCO stopped them, and basically he got down from his car and joined an EOCO vehicle, and the EOCO official joined Wontumi in his car. So he did not describe it as Rambo, but maybe that's your
well, that's the description there, of course.
Fair enough.
So as it is, this is a person who is already cooperating with one of the security agencies. So the needless show of force was what became the immediate trigger of the minorities, furore and indignation. So it was more or less like, so what is it about this gentleman that you invited him by one security agency, and then another security agency also goes to pick him up? What if maybe the day that EOCO releases him, at the time, that was the thinking. The day that the EOCO decides to also release him, is the NIB coming to pick him up, and then next OSP will pick him up? We thought that was abuse of state power. And then, it sent a certain signal of, some amount of political vendetta against a political, party, opponent, more especially the chairman of one of the political parties, the biggest political party in the opposition. So we thought that was wrong, and we needed to send a certain statement. So that was the reason. And then when they got there, of course, they didn't get access. At some point, they didn't even have, seats to sit on. So people said, well, why were they sitting on the floor? But there were no chairs. You know, how long can you be standing? You understand?
But is EOCO a place for for the number of MPs who went there? Is it as a large place that can have a seat for uninvited MPs who come there without prior notice?
I don't know whether you've been to EOCO before, but they have facility, they have offices, you know, conference room that can contain almost all the MPs that went there that day. So I don't think that, you know, they were doing anything wrong. Of course, look, in a democracy such as ours, it's a growing democracy. Of course, it's one of the most enduring since, you know, the First Republic. We need to do things differently. We cannot say that, you know, somebody was arrested like that before, so we should continue that way. Then we are not growing.
I see.
Then where is the reset? If we have said that we are going to reset, then it calls for new ways of doing things, ways that would accord with the letter and spirit of the Constitution.
Does it matter now, what he's been charged with in the minorities' decision to protest in Parliament and walk? Did they avert their minds to the specific alleged offences?
Now, at the time that the minority walked to the offices of EOCO, nobody even knew exactly what the charges were.
Okay.
We knew what the charges were at the CID.
Okay.
Had to do with, you know, mining without license, you know, mining within a concession, a forest reserve, and so on and so forth. So those were the issues. So we were all at sea as far as the EOCO charges were concerned. But later on, we found out that it had to do with tax evasion, fraud, money laundering, and so on and so forth. There were 6 charges. For the specifics, one is not to, but it is becoming clear that one of the issues that the EOCO is using against Chairman Wontumi is about an exim facility. That's what is being speculated right now. Now, if you go for a facility from an agency like Exim Bank, what are the remedies available to the bank in the event that, you know, for the want of a better word, you default? Isn't it to take a legal action against the person? So this is entirely a civil matter. As far as my assessment, you know, goes. It's entirely a civil matter. And from what we are being told, the matter is even already in court. Exim Bank has already taken Chairman Wontumi to court, and the matter has been, you know, fought in court. So I don't know which aspect of this matter that EOCO is handling. So we'll be waiting for further and better particulars, you know, from EOCO to get a very clear understanding as to exactly what the specific charges are. Then his lawyers will be able to have their client have his day in court.
All right, let's take the initial comments of Alhaji Inusaf Hussaini, who is a former MP for Tamale Central, a lawyer himself, a former minister for many portfolios. You yourself were a former deputy minister for transport.
That's right.
Alhaji was a former minister for lands, which was a more prominent role among others. Alhaji, thanks for
Minister for Roads and Highways.
He's been minister for many important portfolios. Good evening, sir. Thanks for joining us.
Bernard, thank you for having me.
It looks like life out of government is good for you. You are smiling, you look very good. No stress, nobody's calling you about roads to be fixed. Nobody's disturbing you about the Fufusu Solar Road. So you are very happy.
Now we fixed the Fufusu Solar Road before we left office.
I know, but it's in a state of disrepair now. I think it needs a lot of work.
That was 8 years ago, or more than 8 years ago. Yes.
Yeah. And of course, Galamsey is still an issue. So the sectors that you used to manage, still with many, many issues. But let me not even push you there too much. I'm sure you've been following these 2 issues. The Wontumi matter. Today will be a week since his visit to the CID, and he's been held for a week, essentially. The minority believe that state power is being excessively used to target a political opponent. What are your thoughts on that?
Well, you see, when you are dealing with the investigation of alleged criminal activities of citizens of this country, the only thing that we can ensure or talk about is whether such activities fall within the confines of the law. Because the protective safeguards, or there are protective safeguards for citizens who are subject matters of interest and who are being investigated for various acts or commissions that they did while, if they are public officers, while in public offices, offices, or if they are private individuals while carrying out their private activities. Now, and the most important constitutional safeguard is especially for people who have been arrested, detained, or restricted, to be submitted or presented before the courts within 48 hours, or make arrangements for them to be released temporarily on bail, or to release them all together if the investigative authorities have no reasons to continue to detain, restrict, or arrest those people. So that's a very important constitutional safeguard. In the case of Wontumi, yes, he was arrested after leaving the CID office. The EOCO were quite aware that they could only hold him for at most 48 hours, and if after the 48 hours they still required him in police or EOCO custody, they had to go to court. But if they didn't want to go to court, what they could do was to give him bail, so that he will be attending upon EOCO anytime he was required to do so. My understanding of what happened was that a bail was issued to him. I mean, he was granted bail in the sum of 50 million Ghana cedis and 2 sureties to be justified. His inability to meet the bail terms does not in any way suggest that his rights had been violated. No. The EOCO had granted him bail. If on the day he was granted bail, he was able to execute the bail, meet the terms and conditions under which he was granted bail, he would have walked away from EOCO, but only attend upon EOCO anytime he was needed to do so. So it is my humble view that having granted him bail within the 48 hours allowed by the Constitution, a very important constitutional safeguard for his rights and liberties as an individual of this country, EOCO cannot be said to have been in breach of any law.
Wonderful. We are told, however, that at least some members of his team claim that he had secured or met the bail conditions as of Friday. But we were told that there was a dependency of a case filed on his behalf against EOCO, which was to have been heard tomorrow, Tuesday, which sort of delayed his release. And therefore, we're told that today they had to withdraw that case to allow for his release. Do you understand that whole confusion? Because for us non-lawyers, we don't really get it. He's sort of met the bail condition, yet there's a pendency of a case, so he will still be held. Is that the facts as you've been told, and does that make sense to you?
Well, so on Friday, I mean, obviously, no one, I've heard people say that they were going around looking for 50 million. No one was asking Bernard Bosiaku to provide 50 million Ghana cedis as bail bond. No, it was 50 million. That's the condition of the bail. And the 2 sureties must be justified. That means they must have landed properties.
Okay.
That is in their name, which they can use to secure or as a security for the release of the accused person. Now, when the court or an administrative body grants bills with terms like sureties to be justified, which sureties or security has to be provided for with landed property, the investigative body will have to go to inspect the properties, inspect where the sureties live, go to the land title registry to verify the authenticity of the landed documents that have been provided to secure the release of the accused person. Now, when all that is going on and a fresh action, mind you, the bail terms are the administrative action of EOCO.
Okay.
Now, so that administrative action is subject to judicial review.
Okay.
Now, if somebody is of the view that, or if the lawyers of Chairman Wontumi are of the view, or were of the view, that the bail terms were harsh and onerous and only intended to continue to keep him because they knew at the time that they were granting the bail that Bernard Bosiako would find it difficult to meet the terms and conditions of the bail, and they were so made to circumvent the law and keep him in detention. You can go to court to argue that the terms of the bill were in effect an attempt to deny him bail because there was no way he could meet it, and they and invite the court to review the terms and conditions of the bill. Now the confusion here is that it appears to me that, and that is what I gathered from Andy Appiah Kobe's statements, that he and his client knew nothing about the fresh application in court seeking a judicial review of the terms and conditions of the bill. Now, EOCO too had their hands tied because even though they were dealing with a lawyer on record, there was another person who was in court seeking to review the administrative decision of EOCO. Now that review could go one way or the other. That review could result in the reduction in the terms and conditions of the bail or an increase in the terms and conditions of the bail. And so, and that decision itself, I mean, nobody knows. I don't have the court documents. You need to understand that if the application was made ex parte, the court might say that, well, because of the gravity of the offense and the matters that have been deposed in the affidavit in support of the application for a review of the terms and conditions of the bail, that application be made on notice. Now, if the matter was on notice, then it requires some number of days for the EOCO to file a response. So that itself, coming late in the day, and particularly on Friday, would have operated to extend the time Bernard Bosiako would be in custody, in the custody of EOCO. So that is why I think that it was a smart decision to withdraw the application today to be able to facilitate the release of Bernard Bosiako.
So Hassan Tampuli here, I think on Saturday, said that particular suit was on the instruction of Mr. Wontumi's spouse, correct?
That is correct.
So, which means that there were different legal things happening around him. Is that normal?
Well, as you just rightly read, at some point when it became, increasingly clear that we had gone beyond the 48 hours, that was on Thursday, there was some amount of, agitation, in the camp of Chairman Wontumi, especially his family, his wife in particular. And so she also obviously didn't even have access to him, all right? And so Andy had prepared, a similar application. The same thing Gary filed, Andy had also prepared one. And Andy's plan was that, from what he has said publicly, that he was waiting as at 3 o'clock on Friday. If he doesn't get any indication that Chairman Wontumi will be released, then he will go and file. So between the two of them, one would have filed anyway. And probably, Gary took the lead to file at 2:35. So if you look on the application, you'll find that it was filed at 2:35 at the Judicial Service. But just let me respond quickly to what my senior brother Yunusa just said about his reference to Article 14.3. My understanding of Article 14.3 is a bit different from his. Article 14.3 says that a person who is arrested, restricted, and detained upon reasonable suspicion of his having committed or being about to commit a criminal offense under the laws of Ghana and who is not released shall be brought before a court within 48 hours after the arrest, restriction, or detention. So the responsibility was on EOCO to have taken Chairman Wontumi to court when the 48-hour period was about to lapse. He didn't need to file any application for variation and so on and so forth. It was now left for the lawyers of Chairman Wontumi to decide whether to go for just the review of the bail conditions or to file a habeas corpus application in court for Chairman Wontumi to be produced in court in accordance with Article 14.3b. So willy-nilly, EOCO should have gone to court. So his continued detention, as far as I'm concerned, was a violation, and I keep saying egregious contamination of the Constitution.
Okay.
So you must bring him within 48 hours.
Okay.
Whether he meets the bail conditions or he doesn't meet the bail conditions, and this is very, very clear.
All right. Let me add something. You said you felt that having gone to CID, then being detained by EOCO, it looked like there were other agencies that were going to arrest him. Indeed, the majority chief whip on Saturday also said that the Financial Intelligence Center has built a new case against Wontumi. So that suggests that there was a third leg of the argument. Again, is that regular? So because it looks like the CID dealt with matters of mining, EOCO dealt with issues of loans and financial loss, and the financial intelligence, we are told, has to do with a more complex web of financial crimes. From your understanding of those bodies, how does that sit with you?
So you see, clearly there's an attempt to frustrate Chairman Wontumi. The CID, from the scope.
And listen, viewers, by the way, this is the release video. So that's the MPP General Secretary working with the former General Secretary and Chairman Wontumi, who's in a reddish attire upon their release. So Justin Kodia Frimpong and Chairman Wontumi coming out. So please continue.
So we're discussing the,
so you're saying that
issue about
FIC,
the multiple
multiplicity of
exactly,
and that's Brian Champo, by the way.
And I've made the point, especially on the floor of parliaments, that too many of these agencies are becoming too much, not only on the taxpayer but also obfuscate a lot of things that we do. CID, I believe all of these that we're talking about can competently prosecute a matter of
by the CID alone.
CID alone, I believe very strongly they can look for the relevant provisions under the Criminal Offences Act and other extant laws of the Republic to prosecute this case competently. Now, there are areas that EOCO has specialization in. Special prosecutor can equally tap a person for the same offense that EOCO can also get. Similarly, CID can also check, arrest a person for the same offense. So it's as if they are passing him to themselves. They are calling each other, Charlie, I've released a man, so it's your turn. They are going to be passing him like a football. So as soon as they release him, and then, what's the name? Now, we are not too sure whether by now OSP is hiding somewhere waiting to pick him up. Or maybe the NIB. So this is a violation of his constitutional rights. The person is considered innocent by our criminal jurisprudence and in the common law jurisdiction generally. A person is considered innocent until proven guilty or he himself, goes to make a confession. All right? Now, Chairman Wontumi is being treated like a criminal already.
Well, the Deputy Attorney General Sensai had said that Wontumi was being investigated for alleged criminal offenses, and then he listed them: fraud, causing financial loss to the state, and money laundering, which appear to be different kinds of offenses so that
CID can prosecute for fraud. They've been prosecuting Ghanaians.
What about the money laundering charge?
Yes, they can prosecute. They can look for a provision in the Criminal Offences Act to charge him for money laundering. They can look. I'm saying that there are offences that can be committed under other laws that the CID has the competence to charge. To take
so no need
control.
to bring EOCO and FIC
You don't
in.
need to bring all of these agencies in. Sometimes, if it is, especially in this case, where there are some other offences which are already being investigated by the CID. So what are you going to do?
Well, he mentioned a wider international organized crime syndicate. That's the word the deputy AG used, which suggests organized crime, which being the ambit of EOCO.
So wait, Bernard. So today, Chairman Wontumi is being charged by the CID. He goes to court. The following day, EOCO is charging him for a different set of offenses in another court. And then OSP is charging him for
OSP
another
is not in yet. FIC.
Or FIC is charging him for different. I mean, really, that is,
it should be consolidated.
It is abuse of the,
I'll take a break. When I come back, I'll ask lawyer Inusa whether he agrees.
It's completely needless.
We'll be back with this. This is the point of view tonight. We're digging into two issues. Chairman Wontumi released. We're just trying to understand the matters. When we come back, we'll also look at Keno Freata, now declared wanted by OSP. Stay with us.